So I thought, we thought we will have a session to enlighten our members regarding the medical legal aspects of our clinical practice. In fact, the general characteristic of a medical practice is whenever he or she hears about case, court and all, they will get scared. So nothing will enter their head. Actually, it is nothing like that. You have to be bold enough to, there are people, hardcore criminals walking around scot-free. And we are doing so much of work for the society, and then being afraid of small things to harass us. That is the thing. That is why everyone should be knowing about their all this, their rights and all this stuff. So you may be knowing him as a veterinary surgeon. That is different. Then he will be talking on the liabilities of a medical practitioner, what we should be aware of. Then we are fortunate to have Dr. Anand Vinayakar, postgraduate diploma in medical law and ethics from NLSU, Bangalore. He also happens to be a great ROP specialist, passionate ROP specialist, international, but he is having another role here. So we will directly go to Dr. Ashok Nagaraj, 10 hours, right?
Thank you, Dr. Mahesh, for that kind introduction. And let me introduce Dr. Mahesh also. He is not only a veterinary surgeon, he also holds a postgraduate diploma in consumer-related law. So he is also even more qualified than all of us. So the topic for me is liabilities of a medical practitioner and related laws. So the whole concept is, as far as medical negligence and things go on, see what exactly is our stand and where have we gone wrong. Now, who's afraid of the big bad wolf? So negligence, so the whole concept is you cannot expect a doctor to know everything. So the whole concept is you have to provide reasonable care to the patient. You have to provide standard of care to the patient, and if you fail in it, then only it becomes negligence. Error of judgment is never negligence. Okay, because we are all human beings. You cannot be perfect all the time, and in retrospect, you can always say that somebody is right or wrong. So medical malpractice occurs when a healthcare provider strays from the recognized standard of care in the treatment of a patient. So that is a basic concept. Now, what is standard of care? Now, standard of care is defined as what a reasonable, prudent medical provider would do or would not have done under the same or similar circumstances. So, if you look at negligence, it is not only that you are doing, it is not doing also is medical negligence. Not acting as well as acting in the improper way. So, if you are doing some medical negligence, so what are the aspects of law that you come under? There is something called as a tort. Tort means it is a civil wrong. Okay, it is a civil wrong. So, civil wrong means if you do a wrong, what is the remedy? Remedy is damages. Damages means you have to pay some compensation as money. Okay. And in tort, the problem is the damages are called unliquidated damages. So it is not that the amount of money that you have to give is determined before. The court will hear, the person who has been wrong will say that I want this much money, and based on that, the court will decide how much money should be paid to the person who is affected or don't have to pay. So that is called as unliquidated damages. Unliquidated damages means damages, the amount of quantum of damage that is paid is not determined before. And the second aspect is it will come under the Indian Penal Code. So Indian Penal Code means it is a criminal offence. It is not a civil liability, it becomes a criminal liability. So criminal liability means, see, you are operating on a patient. I am not talking about ophthalmology. You are operating on a patient and the patient dies. See, how can you say the doctor has murdered the patient? So there, it will not come under first degree murder or anything like that. It will come under if you have not taken proper care and because of that the patient dies or something happens, it will come under rash and negligent action on the part of the doctor. So it will be like culpable homicide not amounting to murder. It will come to that stage. Okay, it is not that you have murdered somebody, but something like you have driven a car very rashly, you have hit on somebody, something like that. Because in criminal liability, there are two aspects. One is mens rea and the second one is actus rea. Mens rea means you should have an intent to perform the criminal act. Like, you cannot just say that, you because of your action somebody died. It has to be proved that the person had an intention to kill him and that's why he killed him. Then only it becomes a first degree murder. Otherwise it will become a rash and negligent action resulting in murder. So this is what is criminal liability as far as medical legal cases are concerned.
Civil liability is between two individuals, while criminal liability is between the individual and the state.
Yeah. So that comes when you conduct a case. So when somebody is murdered, So the victim doesn't have to give a case. The state will run the case for that person. Because in a criminal case, it is a state versus the person, the defendant who has committed the crime. In civil liability, as Dr. Mahesh said, it is between individuals. It is state nowhere comes in the picture. Then comes the Indian Contract Act. Now suppose you are treating a patient. There is a contract between you and the patient. You have taken some money, you have said that you will cure the patient. So that is a contract. So here, the quantum of money is liquidated damages. Because you know the quantum of money, you have taken this much money, you have said that you are going to treat. So under Indian Contract Act also, there can be a breach of contract if the disease is not cured or whatever. So that is liquidated damages. Probably you have to repay the money that you have taken from him for surgery or whatever. And then comes the Consumer Protection Act. So the main point here is, see, if you run a civil case, criminal case, it is a laborious process. See, like our state, what it does is, it always stands with the victim. Okay, so if you look at the accident, the person might have been drunk and he is walking zigzag in the center of the road. It is not your fault that, your car hit the person and he died. But the victim will always be protected because he is the affected person. So the basic concept of laws in our country is protect the victim. So Consumer Protection Act is an act where the person need not go through the ordinary courts. They have a quasi-judicial system which is equivalent to the civil code, which has been established so that consumers have an easy way to address their grievances and claim compensation. So Shanta case that Dr. Mahesh will say, our medical profession also comes under the Consumer Protection Act. But if you see, consumer means, a person is providing you services, you are giving him money. So that is the relation between the consumer and the client, or the person who is receiving the service. If you see, lawyers don't come under Consumer Protection Act. Lawyers, there is no consumer protection. If the lawyer is negligent, he doesn't come for your hearing. Because of his negligence, the case goes off. He doesn't come under consumer. But as doctors, they also take money. They also give service. So, see, I'm not saying that somebody is right or wrong, but life is always not fair. Okay. So this is what I said. Because negligence doesn't arise just because of a wrongful conduct by a person. It is essential that misconduct has caused foreseeable harm to the other. If there is no harm, there is no negligence. So as far as civil liability is concerned, there should be negligence, as well as because of that there should be an injury also to the person to whom the damage has been done. And the money, everything depend on the extent of loss, and I just talked to you about unliquidated damages. Now as a breach of contract, as a crime, so guilty mind and guilty action, mens rea and actus rea, that is what we say. Now this is medical negligence under consumer. Then there is another concept called res ipsa liquitor. Res ipsa liquitor means the truth speaks for itself. That is what we have learned in forensic medicine. Suppose in any case, it is the duty of the person who has been affected. The victim has to prove that the other person has done wrong. He is guilty. Okay. But there are certain situations. Suppose in a rape case, the victim doesn't have to prove. The person against whom the allegation has been made, he has to prove that I have not committed rape. In a similar situation, there is something called as res ipsa liquitor in medical negligence also. Suppose somebody operates. He accidentally leaves his scissors inside the abdomen and he closes. After 6 months, they find out that there is a scissor inside the stomach. Now the person gave, because of his operation, scissor is there inside my stomach, and because of that I have been put a lot of trouble. Now the victim doesn't have to prove that this doctor has put the scissor. It is now the duty of the doctor to say that I have not put the scissors inside it. Automatically it has come from somewhere, I don't know, like that. Okay? So that is the concept. So this is one. When the result is so obvious, the damage is so obvious, that in that situation, it is the duty of the doctor to prove that. So this all comes under gross negligence. We are not talking about ordinary situations. So this is all. So liability in medical legal cases, civil liability, then criminal liability and all that. So details and all Dr. Mahesh will say. Now you have done. Suppose you have been negligent, or you have not been negligent, and a case has been put against you. So what are you going to do? Now, why a medical legal case comes is usually it's because of a communication gap. You have not really, mistakes can happen. Patients are really forgiving. If you really talk to them, communicate with them, etc., usually they are okay. They don't do anything. Another thing is you refer the patient to somewhere, and their PGs will see, fellows will see. And you have been a fellow, you have been PG. In your enthusiasm, you say, who has done this, like that, you will say, means that stays in the mind of the patient. and he feels something wrong has been done. And an unfavorable outcome. If what is not desired is the outcome, then again patient is going to feel bad. Now, once you get a consumer protection, once you have a medical legal issue, 99.99% will be filed only in a consumer protection form. Okay. So where you have to file is like if there is up to 50 lakhs damage is claimed, it is filed in the district form. Now there is something called as territorial and pecuniary jurisdiction. Pecuniary means the amount of money you are claiming. Depending on that, you have to file in district, state, or national form. And territorial means if the incident has happened in Calicut, then you have to file in the district forum in Calicut. Or where the victim is staying, or where the person who has committed the wrong is staying, that is where you have to file the particular case. Now, if the amount of money claimed is between 50 lakhs and 2 crores, then you have to file in the state form. And above 2 crores, you have to file in the national form. So, it depends on the amount of compensation that is claimed. That is where the case is going to be held. Now, why people file in a consumer protection forum is, see, the amount of money, see, usually in a civil case, when you file a case, you have to pay 10% or 5% of the amount of money you are claiming in that particular suit. You have to put it there as court fee. Then only you can file the case. So if you're claiming 100 crores, see, you have to spend a lot of money, just to file a case. But in consumer protection codes, the amount of money, if it's like less than 25 lakhs, you don't have to pay any money on it. And the process is so easy, you just have to write in a plain sheet of paper and give it. And the person who is agreed, he himself can conduct the case if he wants. So all these, video conferencing, email communications, all these facilities are available to the agreed. So everyone goes for consumer protection, and there is a time bound also. Within 4 to 6 months, it has to be cleared. Usually it doesn't happen like that, but still that's what they say. Now see, up to 5 lakhs, you don't have to pay any court fee. About 10 crore, if you claim, you have to pay a court fee of only 7,500 rupees. See, you have sent some money. If you get money, it's good, no? It's very good. So that is what I'm trying to tell you. This consumer protection forum is a forum for the victims. It is not a forum for the doctors, you have to understand very clearly. It is so friendly to the victims. But see, doctors are also given a fair chance. It's not that they are being victimized, but you should understand the trend. So you have to be very careful and be very vigilant. That's what I'm trying to tell you. Now there is something called as limitation period. So suppose an incident has happened, a cause of action. We call it in law, there is something called cause of action. That is the incident which led to the particular case. So 2 years is the limitation period. Okay. Then as Dr. Anand, he is an ROK specialist. So when the child is very, very young, the child loses its eyes because of negligence or not negligence, whatever it may be. So don't think that this child, now 2 years are over, he cannot give case against him. The limitation period for a child, it starts only after the child becomes a major. So 18 years, up to 22 years, the child can give a case against him. That is very, very, very important. Okay. And the second thing is this 2 years limitation period can be condoned also. It is not that it is followed very strictly. Now the patient says, I was in the ICU for 3 years, I could not give a case. Or I was in Gulf, I was in Antarctica. Then okay, you can give. They will condone it. Okay, so that's what I'm saying. This forum is for the victim. It is not for the doctor. Now, see, this is all what I said, And what happens is you will get a notice from the forum once they have accepted the case. And accepting the case also, they are very careful. It will be scrutinized. And once they feel that there is something, you will get a notice from the Consumer Protection Forum. And then you have to give a reply within 30 days. That is very, very important. See, suppose you don't give a reply, it is as if, you don't have a difference. It will be decided solely based on the whatever arguments of the client and not the doctor. And the maximum time given is up to 90 days to give a reply. And for 90 days, you have to give sufficient reason why I couldn't give a reply within 30 days. Okay. Then the reply will come. Then again, they will, they will give another reply to your reply that you have given. And then if you look at district forums, you have to go there and fight your case. You have to go physically to the court and fight your case. If you look at the national forum, it is through interrogatories. There is something called as interrogatories. Interrogatories means whatever questions you want to ask the person who is affected or the patient wants to ask you, it will be in a question answer form. Question answer form which will be mailed to the person. It will be mailed to the court will give it to the concerned person. The answer will be taken and it will be, considered by the particular court. It is not through direct physical interaction. It is something called as interrogatories. You don't have to go to the National Commission to fight your case. Through your lawyer, you can file interrogatories and discoveries. Another important thing is there is no surprise in litigation. That is the most important thing. So you see in movies, suddenly a new evidence will come. Everyone is surprised. See, I'm gone. No, not like that. And now, whatever evidence you have, whatever evidence the person who is damaged has, they have to share. You have to give sufficient time to each party to examine the evidence and give your defense. So that way you don't have to worry. And then comes the judgment, and it will be converted into a decree. Decree means a short form of the judgment. Now, what is the appeal? So suppose district forum, you lost your case, you can appeal to the state forum. State forum, you lost your case, you can appeal to the national forum. National forum, you lost your case, you are can to Supreme Court. So that's what. And in Supreme Court, if you have to appeal, you have to pay 50,000 or 50% of the amount that has been given as award to the victim. So that much amount you have to pay, and then only you can file an appeal in the Supreme Court. So that is the basic thing. So the most important thing is, when you have a case, the lawyer doesn't know anything about medicine. The lawyer, you think he is going to spend 30 days or 1 year looking only into your case and making arguments. You should not feel that like a doctor, you have gone to the doctor, now it's not like that. It is your responsibility because you want to win your case, and lawyer doesn't come under consumer protection also. So it's very important that you go with the lawyer, call him, give him interactions, give him input, write things for him. Then only there is any chance that you are going to win the case. So the thing is, law favors always the vigilant. Vigilantibus, not dormantibus. That is the Latin saying. Law always favors the vigilant. Take all precautions. Thank you very much.
Thank you, Dr. Ashok. Yeah. He's good in that. So, any other? Yeah. Yeah.
Where the doctor is, in a panic situation. And so what are the things that the doctor has to do? Does it come under your talk, or does it come into?
No, as far as a doctor is concerned, no, he doesn't have to inform the police or police station or anything like that.
Yeah.
So he has to explain to the patient, he has to send the patient for a post-mortem, come with the report. Now the problem comes when the bystanders feel, see, in a criminal case, there is something called as an FIR, first information report. Any person who is aggrieved, they can go to the nearest police station and say that this person killed me, he tried to stab me, everything. The police will come, they will inspect and they will take an FIR. So as far as a doctor is concerned, there are certain guidelines that the government has said that you cannot immediately arrest, you cannot immediately take a case. You have to study what exactly is happening, and it is what you say. You have to be sure that it is not a ordinary. Then only you can file a case against the doctor. Doctors are protected to that extent. And if you look at rape also, there are exceptions to 375, section 375 rape, where medical examination is not considered rape.
If such a thing happens, if the patient's bystander is not keen on a post-mortem,
no, post-mortem has to be done.
It has to be done. If you are not doing, I think you will have to get it in writing. Because later they should not say.
Yeah.
We have advised postmortem and they have not agreed. That is their fault. Then we should push for postmortem. That is the thing.
So the only thing is, when if such a case happens, supposing there's a table death or anything, I think the best thing that we have to do as doctors is to make sure our documentation is correct. We are fortunate to be working the ophthalmic specialty, but let's say ICU, orthopedic, anywhere, intensivist, the first thing they will look at is the documentation, including who conducted what were the investigations done, vitals when it was checked and so on. So most people lose their case because the documentation is not right. And then inserting documentation later is considered tampering, and then that becomes then a criminal offense.
Then
Until
we
then
lose the
you're a
case.
civil offense.
Nowadays everyone takes a photo after this thing. It was not that we have added. Easily it can be found out. Then we lose the case.
And one more thing, the amount of time you have to keep your documents. They say for IP it is 2 years, 3 years. There is nothing like that. If a case comes after 10 years, if you don't have the document, you won't even remember who the patient is. You are saying that I need not keep documents. It's not a defense at all.
It's not a defense.
Suppose there's a death on the table. Who is more responsible, the surgeon or the anesthesiologist?
Both. Actually,
There's something called vicarious liability.
vicarious liability.
And so yeah, actually both. In fact, if you're let's not go to depth because let's talk as ophthalmologist. But let's say your postgraduate has an infection, post-op end of, you as the surgeon will be liable. In fact, there was a very, very famous case from Kerala state, which then, sort of a landmark case from where all of this comes many years ago, from camp-related infections. The surgeon and the postgraduate who operated were completely acquitted. But the case went against the hospital because they found that they had not taken permission from pollution board. They found that their operation theatre was not in a place where it should have been, sterile. So they found all regulatory lapses. They never said that because you operated and that 69 patients had post-op end of 61 out of them went to no PL. This is some, long 2008 case. So all of that can be protected if the documentation is full.
And one thing is vicarious liability. If you have a junior operating under you, the senior is also responsible. It's not that, I have not operated my junior. No. Even the management is responsible. So that is what we talk about vicarious.
Yeah, actually it will be first doctor or anesthetist, then medical director, then hospital name, like that you will come. So, okay, I will go to the next.
One last thing.
Yeah.
I think this 2-year thing, I think you'll have to emphasize.
No, it is
I don't
not
think
2 years, sir.
it is not 2 years.
It is
That
not
has
2
to be
years.
emphasized.
It is not
And
2 years.
we have had issues many years after because the thing is many years later he realizes that some problem is coming because of the vision. Because because some job, something. At that time he wakes up.
So the reason why that 2 years did not apply is there's a Supreme Court hearing on something called a theory of discovery. So basically it came out when there was a tubal ligation and one tube was not ligated and she became pregnant. So she went to the consumer court saying, I did not know that I thought when I went for a sterilization.
Sandra versus State of Punjab, I think.
There you go.
Yeah.
So basically the court said that she discovered that she was pregnant only after 5 years of the first surgery.
Yes.
So how would she know that, so even though it was not 2 years, it was 5 years, they allowed that case. Using that as a precedent, unfortunately, that 2 years does not hold any good.
Yeah, in that case, the doctor was found negligent. There was similar case, another one where the fertilization failed. I mean, that sterilization failed. But that Supreme Court, Shivaram versus State of Punjab, they said that every complication of the procedure, the doctor is not liable. That is for the doctor. We can always quote that. Every complication of the surgery is not the liability of the doctor. Anyway,
And they also say that cause of action is continuing. That's what they say. The disease no, cause of
Yeah.
action is continuing. So you cannot say that.
so again, I am just summarizing what Ashok said. There should be a duty between you and the patient. There should be a breach of contract and a resultant harm. Somebody put a dilating drops and I had some redness, and ideally you cannot go for a case unless you can claim that it's mental harassment and all. So it is resulting harm should be there. So as Sir said, it is difficult to put criminal liability because the problem is the police station people only will decide which this thing to charge, 304A or 304. All these things should not be charged. In fact, IPC 304A causing death by negligence is the worst thing that we can have. IPC 304A, and court has clearly said when you can charge IPC 304A. Unfortunately, everywhere now doctors are charging. In Rajasthan, one time gynecologist committed suicide because the local police person, with the help of a politician, charged 304A and arrested the doctor. That should not be done. And we have some defenses like section 80. Nothing is an offence which is done by accident or misfortune without causing something intending to cause damage. And this 80 and 88 we can always use at our defense. So this case is the most important thing. Jacob Matthew versus State of Punjab. In that case, one old man died. The son created all cases, and he wanted the doctor to be arrested on criminal liability. And this case was landmark in the sense the Supreme Court said what is criminal liability and when a doctor should be arrested. Negligence is a breach of duty, and they defined what is negligence, and they said that gross negligence only you can arrest a doctor, unless that you cannot charge 304A. So this is the basic, but many policemen don't do this. There was another case called Suresh Gupta versus NCT of Delhi, where it was actually a negligence because that cuffed endotracheal tube was not used, aspirated and died. But there also the Supreme Court said that you cannot charge criminal negligence. It was a negligence and consumer protection, they were punished. But gross negligence or recklessness is not there. So they also define. So these two cases define what is criminal negligence when they can charge criminal prosecutions of doctors. So every mishap or misfortune in the hospital or clinic is not gross act of negligence. There is a problem. I think there are two problems. One is what is negligence and what is complication. These two are not clearly known to the public. Yesterday I had a patient after cataract surgery. There was a vitreous hemorrhage. First thing there is kai pidavana, that is negligence. I said it is not kai pidava negligence, it is a complication. So there is a big difference that they don't understand. And there was another case, Kusum Sharma versus Batra Hospital. There also the court clearly said professional doctor is clearly not negligent just because his conclusion is little different. You suggest something, some other person suggests something. These are all cases all of us should know. When you file a reply, you should all quote these things. And so your opinion may be different from another person's opinion. Doesn't mean that you are negligent. And doctors should not be unnecessarily harassed, and they are entitled to get protection. See, few things are there in this verdict. So medical negligence became part of CPA after this IMA versus VP Shanta case in 1995. Then we were included. And later in 2019, it was little more elaborated, 2019 CPA modification. And even now we are there, and the amount, the ceiling of the amount Ashok just told. You should know few things. You should respect the autonomy of the patient. Way back in 1914, Justice Cardoso, this is the first, he said, if you do an operation without the patient's consent, you are committing an assault. So the basic thing is consent. And half of the cases are lost because of bad consent. Okay, that is half of the cases are lost because of bad consent. So autonomy of the patient is of utmost importance. Then I should tell what is Bolam's test. This was a case 1957. Basically, patient had ECT, electroconvulsive therapy for some disease, and then he had a fracture. So he sued the NHS that time, saying that I was not informed. But the court let the doctor loose, let the doctor free, because they said this is a standard procedure and none of the other doctors do this. So whatever has been done is as per the standard guidelines. So at that time, doctors were given importance, doctors were given, listened by the court. Now it is not like that. So, but in India, still this Bolam test is continued, followed. And the court will see whether this is a standard treatment offered by all other doctors. Most of the cases, somebody from the medical college will be called and they will be, okay, this is standard thing, fine, Bolam test, okay, no negligence. So even in India, this is still Bolam test. Now later, there are a lot of examples in India. Martin D'Souza versus Mohammad Ishfaq case, where somebody gave amikacin for a severe urinary tract infection and lost a hearing. But court said this is a standard, this is resistant infection, he has given standard treatment. So he was not negligent. Later, this is another case, Lakshman Joshi versus Trayambak Babu Godbole. This case, what they did was reduce the fracture without giving proper anesthesia and had a shock and patient died. Here, the general opinion of the doctors were they should have given anesthesia. So Bolam test, he failed. So he was made liable. So like this, court will see what is the standard treatment. In India, this is followed, and we have to do what is being written in the books and other ophthalmological group. Now later, Bolitho test came. Bolitho test is little more against doctors. So this was 1957, now it is 97. Bolitho test, basically there was a case with croup, diphtheria, and the patient died of respiratory failure, and lot of doctors said I would have intubated. Some other doctors, experts said I would not have intubated. There was an opinion difference between the doctors. Then the court decided that we cannot take the opinion of the experts like that because there is differing opinion. Court will see which is logical, and then doctor was punished actually. So later the court has taken a step to analyze the result of the expert witness, and then they will decide. So we a little more things are against the doctor. As he said, it is again for the victim, not for the doctors. Bolito's application has been made in a lot of cases. This is Malay Ganguly versus Sukumar. Here somebody gave I think toxic epidermal, Steven Johnson, one variant of Steven Johnson, and they have given steroid and some complications occurred. Then the doctor said this is standard treatment. But the court analyzed the thing, and Supreme Court found out that the dose and the tapering and everything was wrong, and he was punished actually. So court has started looking into the matter little more in detail. So that is the, so don't just, when you have to follow the standard guidelines, but be little more careful. So that is Bolito's test effect. Now court is deciding what is logical, what is not the standard practice, what is logical also. Now more troubles are there after Bolito, especially in US and Australia, Canterbury versus Pence. The shift of doctor-centric verdict has become now patient-favored verdict. Now everything has to be informed to the patient, and patient is the king. So even US and all, Canterbury case and all, if there is any change in the informed consent, you are not mentioned a remote possibility, doctor will be sued. So that is a shift of paradigm. Later, even in Australian court is also still very strict about all these things. Somebody did not mention sympathetic ophthalmia, he was sued after cataract surgery. So this is the extreme. We are not in that stage. We are still in Bolam and little Bolito. So nothing to worry. Now I was talking about some judgments. It is called the judge-made law. There are law is made by legislature, parliament, and it is implemented by executive, and interpretation of the law is done by the court. So Supreme Court say, okay, there is a law, you have to do like this, then somebody will implement. So Supreme Court says in a verdict, this is this. It is a judge-made law, not made by parliament. So it is applicable to everyone. Like, for example, this is a standard Vishaka versus state of Rajasthan. This case, Supreme Court made a lot of things, sexual harassment against women in the workplace. So there is no law like that. But after this, every hospital or every workplace has a sexual harassment cell and all. So this is a judge-made law. Like that, there was another Article 21 of the Constitution says your rights, right to life and right to personal liberty. But there is no right to health in Indian Constitution. So after this Paramananda Katara versus Union of India, where an emergency case was not attended by a lot of doctors and patient died, then court said right to health is also part of our constitutional right. So then it became constitutional right, Indian. So these are all judge-made laws. So we can always quote in our cases all these judgments. When we quote the judgment, our case becomes stronger. So everyone should know. Now this has I have been stressing consent. Half of the things are due to lack of consent. And Samira Kohli versus Prabha Manchanda was a classic case. This lady, 42-year-old lady, underwent examination under anesthesia for a uterine mass or something. And during this thing, laparoscopy or something, they found that there is ovarian tumor. The doctor just went out and asked the mother, only mother was there, unmarried. And she said, okay, remove. Then he removed, Dr. Prabha Manchanda removed the uterus and the ovary. Later, the lady was going to marry someone. And they found that ovary is not there. They cannot conceive. So they gave a case. And in this case, the court has given specific guidelines regarding consent. We are all following true and legitimate consent that is needed for a surgery. Don't do anything outside your, suppose you do a EUA and find a tumor or something. Don't just enucleate. Give 1 more G and then do the enucleation. That's fine. Just tell there is a tumor, can you remove? After 1 day only he will recognize that he removed the eye. So don't do anything outside the consent. This is very important. So unless the patient is a minor or some who cannot give a consent. So medical litigations are due to lack of consent. This study was published. Half of the medical litigations in Korea was due to improper consent. Very clearly mentions. So in UK it is valid and real consent. Valid and real consent given voluntarily by a person who has the capacity to give and competent to give a consent. And you give only minimum adequate information regarding the surgery. Don't tell more complications. In US, it is informed consent. Everything should be there. Nature, purpose of treatment, outcome, alternatives, risk associated with no treatment, then patient will decide. So you have to mention everything. India has not gone to that extent. So element of consent, I said, if suppose the patient is a 16-year-old boy, it is better that you take the consent from that boy also, because they know something more than, so you take the parents' consent, witness, as well as the boy also. So between 12 and 18 is a grey area, and you have to take consent from all of them. Legally valid consent, I have already explained. Then another thing is, don't do anything outside your expertise. Actually, this case was a important case. Some Ayurveda people gave some allopathy medicine and patient died. So clearly they said it should not be done. Now this is becoming a problem in India. Specialization has come in ophthalmology also. Are you a retina specialist? Are you a cornea specialist? Why? So it is better that don't try too much of aggressive management if it is not under your capabilities. So this is also getting important nowadays. Now this one I already said, state of Punjab versus Shivaram. You will not be held liable for any complication. Be sure that you will not be, that is this case, this thing everywhere you can quote actually. And then there is something called confidentiality. That is another pillar of medical ethics, confidentiality. Now this is important. Why this is important? Now everywhere there is webinar, and in fact one of the PG classes of KSOS, the PG who presented so and so name this many years, address also, and showed the face. And this is going into YouTube. I immediately called and said, if somebody sees this, oh, this is our confidentiality, breach of confidentiality means there will be trouble, especially whatever you are uploading in YouTube. So that is important. So you have to keep the, you can break the confidentiality if the disease is a public problem, public nuisance like a transmission disease or something like that. So otherwise you should keep the confidentiality. Now recepts allocator, we already said, that was actually MOP inside, that was Achitrao Haribabu Kodwa versus state of Maharashtra. So that is another important case. Avoid unnecessary thing. Anyway, we can't put gauze piece and this thing inside the eye. Maximum probably you can put is some what I don't know, silicone oil and some sutures or I don't know. Another thing is that no. One recepts allocator case is there. You drop an IOL, put another IOL over it. Many of you might have seen. That is recepts allocator. If you are not told the patient, that is a classic recepts allocator of ophthalmology. And we have cases, we have lost cases. You are not told the patient there is another IOL lying inside. So that is how compensation is calculated. That is another thing. There was a multiplier method used initially, some formula is there. Now it is called the principle of restitutio in integram. In other words, suppose Anand Vinakas, one boy becomes blind. After 18 years he will sue. Then throughout his life, how much he will earn and roughly a percentage of that will be given. So the highest, he will be talking about that in ROP. So highest awarded in ophthalmology is regarding ROP. So younger the patient, more troubles, more. So this is important in our scenario, our coverage in professional indemnity schemes. So you should not take 5 lakh and all. 5 lakh will be okay for a person with some irritation in the eye. Suppose the patient loses vision, it will be 50 lakhs, 1 crore like that. So always take IMA professional protection scheme, enhance your this thing by 10,000, paying 10,000 rupees extra, you will have 1 crore coverage. IMA, all of you are IMA members, I think. So that is the most important thing. Just online you can enhance. We have a IMA scheme. Just enhance it by 10,000 rupees. Every year you have to give 11,000 rupees. But that is the best thing. 1 crore is at least there. So that is it. And then these are some of the cases. Prashant Tanaka case, it was 3 crores or something, 20-year-old student. Then Krishna Kumar, he will tell, Krishna Kumar ROP case, very famous case against Egmore Eye Hospital. It was 1 crore 38 lakhs. And Balram Prasad Kunal Saha, highest probably, it was 7 crores nearly. So these are the amount of thing that now, as I said, CPA 1986 and 2019 has made our life more miserable because that amount they can claim has been increased, and Bihar can now give a consumer protection case in Bihar against you sitting in Calicut. So that is also there. Now that thing is also there. So that is the law of limited jurisdiction, everything, appellate courts, everything has been discussed. Few questions and then we will go to the keynote address by Dr. Anand Vinay. We are already judges of our own rights. Now what is remaining is to become lawyers so as to defend it. Major saying. So that is the important thing. Nothing to worry about all these cases. Yes, sir.
I have one question and one comment. One is for cataract surgery.
Yeah.
If you take our institution, we take informed consent for all complicated surgery. But cataract surgery, you need to take informed consent. For example, in the consent, you are writing phacoemulsification with intraocular lens implantation. But for some reason, you are not putting in an IOL. You couldn't put in an IOL. But your consent has said phacoemulsification plus intraocular lens implantation. So is it necessary to take informed consent for cataract surgery?
Informed consent is, see, there are two things. Printed field consent is not valid. That is the current standard in India. Delhi High Court clearly said that printed consent where you filled phaco IOL and signed is not valid. So you have to at least make the patient വായിച്ച് മനസ്സിലാക്കി read and approved and then sign with the two witnesses and doctors. So this is what the standard thing. In that what you write is the important thing. There is a clause below that sometimes there will be alteration in the procedure. Like if you cannot do phacoemulsification, you have to convert it to SICS. That should be acceptable. But if you don't put the IOL, the basic things should be there in that consent. That's what we have to go through our own consent and see whether everything is there.
In any surgery, no, there will be a clause that any
Alterations.
procedure can be done. If it is there, no, it's acceptable.
It is reasonably acceptable.
Any complication which is not mentioned in your list, no. Even if it is like this,
Yeah.
any complication which is not mentioned consent, it implies that the patient was not informed of that. That's the ultimate thing.
Yeah.
So whatever complications we can mention, no, it's better that it's
At least that most of the things has to be covered in that this thing, IOL, putting IOL, PCR and all this stuff. Mahesh? Yeah.
We only 20 minutes.
20 minutes. Okay.
Thank you for this opportunity. So again, disclaimer is that a lot of my works have actually been done by Dr. Ashok and Dr. Mahesh. So this is not legal advice, and everything that I quote here, especially some of the cases are in the public domain, so I have nothing against any colleague or even the legal profession. So we are in the changing times, I think. The idea is to remember that sacred doctor-patient relationship unfortunately has been eroded, and we now have to pretend that almost every case can actually be a litigious case. I'm on one spectrum because of ROP, as he mentioned. Probably not only the case load is large, but also the duration in which you might have to fight these cases and get punished for these cases go for a very long time. Having said that, the principles of ROP will apply for the rest of ophthalmology, and I'm trying to weave in some of the principles into my talk. This has already been mentioned by Dr. Ashok. So there is negligence, unethical acts, and misconduct. So we know a lot now about negligence. We know that it comes under IPC, TOT, and so on. But there's also a new code of ethics. So Medical Code of Ethics 2021 is now recognized as law. So now you can't say that you have to be a good doctor and a good surgeon and you shouldn't do wrong things and you shouldn't take money from cut practice and that's just a nice person to be. No, it's a nice person to be. But now if you don't do all of that, you can be prosecuted. So my point is we now come, even our ethics and our misconduct is now prosecuted because the code of medical ethics is now recognized as law. So you can actually go not only in the state forum or the national forum, for me it's Karnataka Medical Council, for you it's Kerala Medical Council, but you can actually take it up to the civil courts. This has been mentioned. What is duty? So our duty as ROP physicians or anyone, it begins when we take on the patient. So in ROP it is very different because our patient becomes our patient only when the neonatologist sends to you. Out of the 7 cases that have gone against ROP and one more in Gujarat Rajasthan last month, all of them have gone against the pediatrician. One of them has gone against the ophthalmologist as well. So as soon as we get involved, then we become liable. So that's important. And how long we continue until, and there's a way, either you've cured the patient or in a bigger specialty the patient has died or the patient has decided not to come back to you. So there is something that's called where you stop your duty of care. If you have called a patient who requires, let's say, laser treatment for ROP, and it becomes now your liability. And you've informed, you must document that information, whether it's a phone, a message, an email, all of that has to be documented. Now after 3 repeated attempts, they say, I'm not going to come. The best thing you can do, and I have done this in a few cases, is to write a letter saying that my duty towards you has ended. And we have actually registered, posted that letter to the address provided to us in the hospital. Because tomorrow if the patient goes blind, I'm sure they unfortunately will, because it was zone 1 disease, they will come back and say, they never called us, they never told us the seriousness. And unless you have documented all this, so this is basically that. Now dereliction of course means that you have gone against your duty, and as clearly mentioned, today our courts are taking not just BOLA but BOLITO as well. So we have to be really careful about how we are going, where we are going. These are the 6 most common causes of litigation in ophthalmology in India right now. Number 2 is ROP. So all these years ROP was not even there on the list. Number 1 is still post-op end-off and still camp-related cases, which of course we have now guidelines, and most of us don't do camp-related cataract surgeries. So let's now talk about the second leading cause, ROP. And again, draw principles for that. Even if you all are don't doing ROP, you can sort of translate to what you all are doing in your specialties. So this is one of the largest, setbacks in litigation history. It was 1.8 crores, including the court fee. And this patient went from being a 3-month-old child to an 18-year-old adult. So it went from state forum to national forum to the High Court to the Supreme Court. And not just it did this open out Pandora's box, but it also pulled out a set of formulae on how the court is going to calculate what your compensation would be. And as rightly mentioned, it's not got to do with the age, but also what your parents do. For example, if the parents of the child are postgraduates, then it would be assumed that this child would have some level of education and standing in society, contribute at some level, and therefore the compensation of this person would be calculated that if he was not blind, he would have done this profession, earned this much to society, and all of that for 25 to 35 working years into interest and taking care of inflation will be your compensation. No, but this is a formula. If you read that 85-page judgment on this case, it is pretty scary because it looks like a sheet from a mathematics textbook. And now obviously that has become law. Now these are the very small print, but this is there both in the VRSI journal, and now we've published it as well in a peer-reviewed journal, Asia Pacific Journal, where we have analyzed the other 6 cases for which went against doctors in ROP litigation. And what I summarize here is all those judgments that went wrong, and you can now translate it to the subspecialty that you take care of. For example, we're talking about consent. Now many of us do combined surgeries. We do cataract and vitrectomy. The vitrectomy surgeon's consent has to be different. How many of us do that? If there's an IOL drop, the retina surgeon from the next OT is called in to fish it out. How many of you all know that you have to take a consent separately of the retina surgeon? Because in the Samira Kohli case, one of the 10 tenets is mentioned is that the patient has the right to know who the operating surgeon is. As far as he or she is concerned, you are the cataract surgeon. You called in your retina colleague, patient doesn't know. Tomorrow if there's a complication because of the retinal surgery, you will be liable, not the retina surgeon, because you never bothered to take that extra consent. So actually 2 consents have to be taken. When we are talking about waking a patient up from anesthesia and postponing the surgery, we are under topical anesthesia at best. So where is the justification for us to say that a patient was under drape and so I decided not to take the consent? So these are things to talk about. Not all of these have answers. So this is, I'll skip on this because this is where the pediatrician is. Now let's go to what the ophthalmologist, where the weak links, what the courts have found. So inadequate, inappropriate and improper. Now all these 3 are really important words. We won't get into detail. But let's say we're talking about a screening visit. It could be glaucoma. In a case that I know of, mitomycin C was prescribed after a certain surgery, but in the prescription it was not mentioned for how many days to take. And the patient went into some sort of a scleral thinning. And finally won the case because they said in the prescription you have not mentioned when to stop mitomycin. Only thing, slightly it went into the favor of the doctor because this patient did not come back for follow-up. The court said there is a sort of shared negligence, but so contributory negligence. So that is where it slightly saved the doctor, but he was still held liable. So one is the documentation. The other one is when you have to talk about the visit. You don't just write 2 weeks and 3 weeks. You write 25th November, 2 p.m. which scale, whatever it is. And there are issues like I know a very senior ROPS physician in our country who has written 5th of April when actually he or she meant 5th of April, but that was the person was an NRI. And for him the month was written first. So he thought he has to come on 4th of May instead of 5th of April, you see, because they write the month first. And by the time that patient brought the child, a month later, the child was blind. So, these things can happen. These are cultural issues we may not be aware of, but then they go into court and then there's a problem. Failure to treat on time, failure to explain long-term follow-up, parent care, I'll leave that. Now, how do you prevent litigations from screening? So the most important thing that we should do is apply the most current operational or guidelines. So, for example, in anti-VEGF for adults, there is a VRSI guideline, especially came out after the DGCI banned Avastin and then reintroduced it. If any of us are deviating from that consent, it will be an issue. Not just for babies, but for adults as well. So like that, if there's an SOP given by the government, now there's always a hierarchy. If the government gives a guideline and a state society or a national society or AIOS or VRSI gives a guideline, it's the government one that will work. If there's a state society and a national society, the national society will work. So it is best to always have a unified guideline. That's why we have been working with VRSI and AIOS to have one common guideline and not something different for pediatricians and so on. Consent, documenting, counseling and so on, all of that is important. For one important thing here would be in ROP at least to have a card, the ROP card which you give the parent, that the duplicate information of that should exist with you. And a similar information should actually exist in the NICU, because that's really important, because the pediatrician is then party to this case as well. Otherwise he'll be like, I referred to you, after that you took care, I don't know what happened after that. That should never happen, so you should maintain the duplication there. Treatment, ROP specific, obviously we're talking about consent here, use the correct guidelines. Anti-VEGF, I'll deal with in one or two slides a little later. But these are the standard references that you must have and that you must be following. For example, this was the older one, we don't follow it anymore, we follow a national operational guideline. So if there's a Government of India guidelines, you must follow that, not something that the NNF or the AIOS or the VRSI or the Indian ROP Society made, for example. So this probably I would keep for the ROP session, but there are certain protocols. So think about it in your specialty. What would you do? Maybe there is something like you have to give a drop or an antibiotic prior to a particular surgery. It could be. Maybe in LASIK surgery, maybe in cataract surgery, some of you all follow an NSAID drop before. Then if that is part of the protocol, I'm not saying it is, but if that is, then it should be done. So all of these things should be documented the way it is. And for a ROP, there are very, very standard guidelines, and any deviation from that will be a problem. There are still pediatricians who don't refer 1,750 grams because they say, I got trained in Australia and there only 1,500 and less are screened. Well, that won't hold good in India, so you have to tell them that. So, for example, we have a rule saying before 30 days the first screening should be done. So these are very, very strict rules that we have to follow. And nowadays there's a deviation in that in the national guideline which says you have to screen at least once before discharge. Pediatricians don't know this. So you have to educate them. At the end of the day, we're not just saving our lives from litigation, but we also don't want babies to go blind. And now imaging. So there's a lot of apprehension, how can you allow non-doctors to take these pictures? So now this is part of the national guidelines. You can actually get people to do ROP screening through imaging. And you don't have to do it. You can train and accredit a non-doctor to do it. So this is part of a guideline. Again, not aware. We go to many northern states. South India is much better because the awareness is much better. You go to many northern states, they're not allowing ROP screening because they don't think it's even a problem. And some of them are like, what imaging? Call the ROP specialist. And there's no one there. And you're saying, you're talking about this. So, and this is another thing you have to tell the pediatricians. When the baby is good enough to be treated, when you can do the treatment when the baby is still, housed inside an incubator, why are you delaying a screening? Because they are like, oh, this baby is very sick, let this baby come out of ventilation, then I will screen, then I will send you for screening after 2 months, 3 months. By then the baby is gone blind. So this is something that you have to tell them. And in ROP, at least do not discharge the baby from ROP screening at least till the child reaches 40 weeks. So because that is normal physiological vascularization of the retina. So if you are looking at 34 weeks and saying no ROP and then telling the parent you don't need to come back again, you are asking for legal trouble. I'm not saying clinical trouble, but you're asking for legal trouble. So documentation, as I was saying, keep one form with you, make a duplicate, all it needs is a carbon paper, and then if you maintain this ROP card, and then upload information if you're doing the telemedicine model, and so on. Now, what I'm going to now talk about is a little more broader principles because there are others as well. So the 10 commandments of the consent are here. So I think if you just look at these, you must mention complications. There's one case that went 50 lakhs against a LASIK surgeon, not because the complication was a displaced flap and an epithelial ingrowth. That was not the problem. The problem why he was held liable was because he did not mention dry eye as a complication there. And apparently dry eye is the most common complication of LASIK. That. But the courts knew that, and so 50 lakhs compensation was awarded because dry eye was not there in the consent. not because the flap was misaligned. So I'm just saying, a complication because of your surgery going wrong, you've done a retinal detachment surgery, the retina does not attach. The eye goes into phthisis, not negligence. But if you have done something without, following some of these guidelines, then negligence. So most of us think negligence, we use the English language word, it's like I've been negligent means something I did something wrong to them. That's not legal negligence. So, and then finally off-label. Now this when VRSI fought the ban and fortunately managed to reverse it, this was the case that actually prompted it. So there was this many patients who claimed 50 lakhs each, so it was going to go into crores of compensation, saying that there was an infected bevacizumab bottle. And then VRSI fought back saying, okay, we actually produced 2,500 publications across the world saying how effective and safe this drug is, and showed to the DGCI that if you ban Avastin and you allow only ranibizumab, plenty of our patients are going to go blind because they can't afford it. We are still a middle income country. So what DGCI did was, they said, okay, give us the guidelines. So today what is available on the VRSI guideline is how to prepare that Alicot, what special consent to take. All of us should be following that, because this is really on the tender hooks. Till today it is still off-label. It is still off-label. It is not banned, it is allowed, it is accepted, it is respected, it has a guideline, but it is still off-label. And this becomes an issue when we are using it in pediatrics as well. And this is our recent publication on how we changed ROP practice guidelines during the COVID pandemic. I think India led it. We actually published these guidelines in March 2020, like literally at the end of that, beginning of that first wave, and then many countries followed what we were doing. And finally, indemnity, I think they've spoken about it. Minimum of 50 lakhs, please. And I think if you are in the ROP practice, at least 2 crores. So IMA has it, there are professional bodies have it. What has been advised by lawyers is to break up your amount. So maybe a 20 lakh and a 30 lakh Alicot is better than a 50 lakh completely. And as again mentioned, the records, these rules keep changing, but minimum we must have as ROP physicians would be at least 18 years. And then give chance for that theory of discovery, because if the patient realizes that, oh, I became blind 18 years back because you didn't screen on time, then literally till 22 or 23 years of age, which becomes a problem for all of us because we'll have to keep records for so long. And I just want to end with the ethics. Right? We unfortunately or fortunately have in ROP practices where intravitreal injections are being given for just immature retina. And on the other hand, people who are not qualified are just writing no ROP, not referring to the people on time, not screening on time. So this is going to be really held against you, because today ethics is also under the law. It's no longer he's a good guy, he's not a good guy. Today he's violated the law, he's not violated the law. So that's all I want to end with.
Thank you. Anand, thank you. Yeah, exactly. Right.
Is that time? No.
One question, sir.
There's one question I want.
Yeah.
I mean, see, now we are giving, examining in the NICU, giving laser in the NICU. Now, is it necessary for us to make a file in our hospital regarding this patient, this child? Is it necessary?
No, sir. As long as the treating doctor has a consent directly with the patient, and you are treating it in the NICU bears the responsibility of providing, let's say, the oxygen and the monitoring, and you are going there as a specialist for the treatment. Your consent is with. What they might look at is, do you have an MOU with the NICU? So that I would think is a separate.
Yeah. Okay. Thank you, Dr. Anand, for enlightening us and for giving this talk.
I invite Dr. Mahesh to give Dr. Anand the appreciation certificate and a gift. As a gift, as a token of our appreciation from the committee and KSOS and the Thank you.